my lord.
That's altogether a great deal better, I think.
Yes, most certainly. Thank you.
If you get too cold, by all means, feel free to put your wigs and gowns back on. Right.
Thank you. So, my lords and my lady, you'll recall that I'd introduced the introduction of the two-child benefit rule.
Yes.
And I was about to take you to the regulations pursuant to the regulation-making power. And I should take you first, I think, to tab 3, page 12. So you'll see that a new 24A and over the page 24B were introduced by regulations, and again you'll have the source in the footnote there. And if I can just take you please through 24A. So where a claimant is responsible for more than 2 children or qualifying young persons, the amount mentioned in section 10.1, which was the Welfare Reform Act that I took you to first of all, the amount mentioned in section 10.1 of the Act is to be available in respect of, and there we have the two-child rule, first and second children or qualifying young person in the claimant's household, third and any subsequent child or qualifying young person if the child is transitionally protected, not any materiality here, or an exception applies in relation to that child or qualifying young person. We're concerned with the exceptions, which I will come to. And then subpara 2, a reference in paragraph 1 to a child or qualifying young person being the first, second, third or subsequent child or qualifying young people in the claimant's household is a reference to the position of that child in the order determined in accordance with regulation 24B. And then subsection 4, an exception applies in relation to a child in the circumstances set out in Schedule 12, which I'll just take you to in one moment, but just to look at the ordering at paragraph 24B. 24B, subject to para 2, the order of children or qualifying young person in a claimant's household is to be determined by reference to the following date in relation to each child for whom the claimant is responsible, taking the earliest date first. Where the claimant, or if the claimant is a member of a couple, the other member is a parent or step-parent, the date of birth. So we're looking at, first of all, first child is the oldest, so to speak. In any other case, the date on which the claimant became responsible for the claimant, if an earlier date. But if it's a parental relationship, I suspect, my lord, you'll correct me in relation to all of these terms, but for present purposes, a parental arrangement, then one is looking at just by reference to age. And so one has the two-child benefit rule applying after the second child, the first child being the eldest, the second child being the second eldest. And so when one gets to child 3, there is, presumption is there's no benefit. So if I can ask you in respect of that child, can I ask you please to turn to Schedule 12, which is tab 6. This is dealing with the exceptions, and you'll see at the introduction, page 24, provides for cases where, for the purposes of Regulation 24A, the exception applies in relation to a child for whom the claimant is responsible. And then it deals with multiple births over the page at paragraph 25. Claimant is where the claimant is a parent of the child. The child was one of 2 or more children born as a result of the same pregnancy. The claimant is responsible for at least 2 other children or qualifying young persons, and the child is not the first in the order, so not the eldest. So the simple point being, if the two-child benefit rule applies and you have the misfortune to have triplets, you're not. The rule doesn't bite.
So if you've got one child and you have triplets, childs 2, 3 and 4 qualify. But if you've got 2 children and you have triplets, child 3, 4 and 5 don't qualify. Is that what it says, or is it more complicated? That's right.
It says that where 1 or 2 more children of the same pregnancy,
Yeah.
responsible for at least 2 of the children as a result of that pregnancy, and they're not first in the order as determined by regulation 4. So if you have child 1, eldest child, and then you have twins, you've already had 1 child, so you're not having twins, and that fills the whole gap. You've got 1 child and then 2 children because of a multiple pregnancy, twins. It doesn't bite.
Yeah. But if you've got 2 children already and your 3rd pregnancy is twins or children, you don't get anything for
No.
the twins or the triplets or however many. Yeah.
That's right. That's right, my lord. So yes, my lord, that's exactly right. And then at the next page, 26, it deals with adoptions. Exception applies where the child has been placed for adoption with or adopted by the claimant in accordance with the relevant statutory provisions, but not where the claimant was a step-parent immediately before, has been a parent of the child, other than by adoption at any other time. Again, an exception. So one is accepted from the 2-child benefit cap rule where one has adopted a 3rd child. Do you see that? And then over the page, page 27, what I've described as kinship, recognise the point, this is shorthand. Non-parental caring arrangement. Exception applies where the claimant is a friend or family carer in relation to A, is responsible for a child who is a parent of A. Friend or family carer means a person who's responsible for the child but is not a parent or step-parent and is named in the child arrangements and so on. So in relation to non-parental caring arrangement and adoptions, there's no ordering requirement. And then as your lordships and your ladyship may have seen, there was so no ordering arrangements there, but of course we've seen the original regulations and the ordering arrangements set out there. There was then a claim brought by way of judicial review challenging the ordering arrangements, in particular in the case of kinship care cases. And if I may just take you to that because it's instructive, tab 13, and just for your note, this is the first instance decision of the case that ultimately went to the Supreme Court under the name of SC. And ultimately, the High Court concluded that it was irrational to apply the ordering requirement in kinship care cases. It concerned, I needn't take you to the relevant provisions, but it concerned child tax credits, which were replaced by universal credit, that we're concerned with here, but it was clear and recognised by everybody that the same principles applied. So if I can ask you please to go to paragraph 17, which explains the factual background. CC and CD are an unmarried couple who live together with CC's daughter from an earlier marriage, CD's grandson, and their own child who was born in 2017. CD's grandson lives with them pursuant to a contested child arrangements order. Cancer scare in 2016 contributed to their decision to have a child together. Didn't know of the 2-child benefit rule. Before the birth of their child, both CC and CD were in work. Combined income was around 28,000. They were claiming child tax credit as a couple. Whilst CC is now not earning following the birth of their child, their tapered entitlement to child tax credit will have increased. So it's can be paid in addition to wages. And then, although CD's grandson lives with them under a non-parental caring arrangement, they were not entitled to child element for their own child, as their grandson was not the third child to join the family. So, as I said, there's no ordering at this point, no ordering exception in relation to any of the exceptions. So one is looking at the third child having to be the kinship child or the adoption child for the exception to apply. If they are the first or second at that point, then the exception does not apply. And so just picking up where I left off, CC describes the family situation as just about managing financially but tight. It's the extras and so on, explains the disadvantage that she is experiencing. And then if I can just pick up second line up from the bottom, beginning but in whichever sequence the cared for child became their responsibility, the local authority has not had to fund his care. So in other words, they've saved estate money, essentially. And then if I can ask you please to go to page 183. So that was the context, saving the estate money, but nevertheless, because of the ordering arrangements, can't get benefit in respect of their third naturally conceived biological child. And paragraph 93 onwards, paragraph 93 to 96, perhaps don't need to deal with this in any detail, simply to say that Mr. Justice Ousley, who was hearing the case, concluded that Articles 8, 9, 12 and Article A1P1 were not engaged. That position changed in part by the time it got to the Supreme Court, but weren't engaged, but there was nevertheless a rationality decision too. And if I can ask you please to look up page 215.
So did he decide then that there wasn't a breach of Article 14 because it didn't fall within the ambit of 14?
Yeah.
So you wanted us to go?
Paragraph 215, which happens to be at page 215. Do you have that, my lord?
Yeah.
Paragraph 250, issue here relates to the 2000 regulations and not to the primary legislation, and that's the position here, my lord, and I'll pick that up in due course. Mr. Drabble contends that the exception in relation to a child cared for by the family is perverse because the availability of child tax credit for a third child depends on whether the third child was born before or after the family began to care for the second child. So one might say fairly random, and we say the same here. Mr. Higlett, that's the witness, suggests the justification that because the cared for child is not to be treated as ever any less value, point that was contended in this case, my lords and my lady, then a natural child of the family and the family caring for a child should face the same choice about a third child as would a family not in receipt of child tax credit. The sequencing provision is rational and justifiable. So once you've got two children, however you've come to be responsible for them, the third is a matter of choice for you, it's assumed to be, and it triggers the two-child rule. So as to rationality and justifiability, paragraph 216, I don't accept that. I do not think insofar as it was seriously considered, there's any rational justification for a parent's decision as to whether to have a child of their own to be affected by whether that decision was made before or after another decision as to whether they should care for someone else's child. So, perverse, which could need to be made quite independently of a decision about having their own child. The purpose of the exception is to encourage, or at least to avoid discouraging, a family from looking after a child who would otherwise be in local authority care. And goes on, of course, to indicate that that would be saving the state money, and so consistent with one of the aims of the two-child benefit rule, which was an economic aim. Fairness and
You're not raising a domestic law rationality challenge in this court to these regulations, are you?
no, we're running the convention rights because, as your lordship will have observed,
They subsequently fell within, but this doesn't directly assist us, does it?
save for the observations about the perversity, even on a non-rationality challenge, in assessing proportionality, one will be looking at whether there is some rational basis when weighing up. Well, there has to be a link, my lord, and when weighing up the aim, when undertaking the balancing exercise, the random nature of the provisions will be a factor that will be taken into account.
At the fourth stage of the test,
Yes.
fair balance between
Yes.
is what you're, okay?
And just as in the case of a kinship relationship, a person having responsibility for that child may find for themselves in a position which is entirely random so far as the third child is concerned. Similarly here, we say, and I ask rhetorically with respect, why is it that obtaining benefit for one's third child depends upon when one was raped? And so the first or second child attracting benefit, but the third not. And you will have seen in relation to the, let me come to that, but in relation to the non-consensual conception exception, again, as with the others, it's only the third child that is accepted in the case of rape. So the first and second, even if they've been rape or coercive control, matters not. A woman may be deprived, the obvious point, as you will have seen in the arguments, woman may be deprived, so far as the benefit system is concerned, of having a child with a person she wants to have a child at a time that she wants to have a child, consensually. As a result of that decision, further amendments were made to the regulations, and if I can ask you please to turn to tab 7, page 34. Amendments were made, and we see that page 34, paragraph 3, paragraph 3, identifying the amendments, and you'll see those ZA 1, 2, and we see them in the context, if it's more helpful to look at it this way, of the regulations by looking at tab 4, page 16. So although Schedule 12 didn't apply, wasn't amended, forgive me, Schedule 12 wasn't amended, ZA introduced the following: any child or qualifying young person in relation to whom an exception applies in the circumstances set out in paragraph 3, adoptions, or 4, non-parental caring arrangements, they will be entitled to benefit. So the amount mentioned in section 10 in respect of any child where they adoption and non-parental caring arrangements, and then A, the first and second child or qualifying young person, the third and subsequent child or qualifying young person in the claimant's household if transitional or an exception applies, non-consensual conception being one of them. So in other words, where adoption and caring arrangements apply, any child will be, benefit will be afforded or awarded in respect of any child, whereas in relation to those not covered, still it's the third child, not the first and second. So that was the subject of challenge in these proceedings. It was contended that by failing to include an exception in the same terms or the same material terms in the case of non-consensual conception, there was discrimination both in the differences in treatment between the non-consensual conception exception and by reason of a failure to make provision different to that ordinarily applied in the case of parents or mothers whose children were not born of non-consensual sex. So what sometimes is described, my lords and my lady, and I know my Lord Justice Lewis will be very familiar with it, the direct discrimination and the Claimants discrimination. Should have made an adjustment to cover my client, made an adjustment to the non-consensual conception provisions, and should not have treated her less favourably as compared to adoptions and non-consensual, kinship arrangements. As to the important case that provides a context for these proceedings, can I take you to SC in the Supreme Court? This was a full-on challenge to the two-child benefit rule. We don't do that here, I should say. Contained in primary legislation, and you'll find that at tab 16. It was a discrimination claim. Both argued that it disadvantaged women in particular, as would be obvious perhaps, because women are more likely to care for children as compared to men. So a two-child rule will adversely impact on them. And in relation to children, as to what the Supreme Court found or decided, can I ask you please first of all to look at page 312. Paragraph 312, bottom of paragraph 41, below B. I therefore conclude, just below B, I therefore conclude, I need to take you through the reasoning, therefore conclude in agreement with the Court of Appeal, but contrary to the view of the judge, that's Mr. Justice Ousley, that the complaint of the adult appellants in the present case falls within the ambit of Article 8 taken together with Article 14, paragraph 42, the Court of Appeal differing in this respect from the judge held that the complaint also fell within the ambit of Article 14 with A1P1, and then at 43 it was accepted however by counsel for the appellants before the court that only persons entitled to claim child tax credit, that is to say adult appellants, could bring a claim on that basis. No departure from the position before this court. The focus of the submissions were on Article 8.
So did they find it was also, I know it doesn't matter, but just so that one understands it, did they find it was also a breach of Article 14 read with Article 1 first protocol, or was it just Article 14 read with Article 8?
In terms of in terms of triggering Article 14, my recollection is, let me just take you to the page number because it may well be there. If I can take you please to 314 because that may answer the question. That doesn't answer just may I just take you through it, and I suspect we'll come to it, but if not,
that will become clear. It's just that we don't want to say it's Article 1 first protocol accidentally, if in fact it's not.
No, absolutely. And I can see from the held, and I have no reason to disbelieve this, I don't see the held, file complaints that the two-child limit indirectly discriminated against women as compared with men, contrary to Article 14 with Article 8
Oh, with
and
Article 1, yeah.
Article 1.
Okay, so it's both.
No, I think if one goes down, I think they are concerned about Article 8.
So it's the end, it's paragraph 43, the focus of the submission.
Yes, as I just took you to my lord, you'll have seen at paragraph 43 that I took to you a moment ago, the focus of the decision was on Article 8.
Yeah, I got that. It was whether also it was a...
But
It doesn't disturb the Court of Appeal's finding on A1.
Well, don't worry, I'll go through it all in
it's just Article 8 that in the end they determine it on. And then at paragraph 54, paragraph 315, the question whether the test is satisfied in the present case in relation to the fact that the limitation is discussed below. They're considering here whether or not there is adverse impact in relation to women, and they find in due course that there was. And at 319, find that there is also discrimination in relation to the children, paragraph 72. A relevant difference in treatment has therefore been established in relation to the treatment of children living in households containing more than 2 children as compared to children living in households containing 1 or 2 children. Remaining question is justification. And then, my lord, if I can take you to make sure I don't miss anything. I might want to if I can take you then, please, to paragraph 199 at page 355. Looking at justification in relation to women, first of all, paragraph 199, once it's understood that the legitimate aims of the measure could not be achieved without a disproportionate impact on women, arising from the demographic fact that they form the majority of parents bringing up children, the only remaining question which can be asked in relation to proportionality is whether the inevitable impact on women outweighed the importance of achieving the aims pursued. Parliament decided the importance of the objectives pursued by the measure justified its enactment. I see no basis on which this court could properly take a different view. Inherent, according to Lord Reid, essentially in the measure itself and what was sought to be achieved, that it would impact adversely on women because they look after children more. And as to proportionality, if I can ask you to look at paragraph 208 on page 357. Having gone through various of the aims and so on, just by way of summary for the purposes of what I'm addressing here, paragraph 208, the assessment of proportionality, therefore, ultimately resolves itself into the question as to whether Parliament made the right judgment. That was at the time and remains a question of intense political controversy. It cannot be answered by any process of legal reasoning. There are no legal standards by which a court can decide where the balance should be struck between the interests of children and their parents in receiving support from the state on the one hand and the interests of the community as a whole in placing responsibility for the care of children upon their parents on the other. The answer to that question can only be determined in a parliamentary democracy through a political process which can take account of the values and views of all sections of society. Democratically elected institutions are far better positioned than the courts to reflect a collective sense of what's fair and affordable, or where the balance of fairness lies. Now, certainly that exercise or an exercise in relation to the legality of the two-child benefit rule, and the exceptions in particular, had already been undertaken by Mr Justice Ouseley, and against whose decision there was no appeal. So certainly there was no suggestion that in relation to the regulations there couldn't be any legitimate challenge.
So the regulations were challenged on domestic law grounds, though, weren't they?
Yes, domestic law.
So they didn't have to...
Well, they didn't have to, in my submission, my lord, in looking at rationality, they would have to consider whether or not they were entitled to interfere. Mr Justice Ouseley was entitled to interfere, and that, in so doing, he had to have regard to whether or not this worked, and then was held that they were unlawful for reasons of irrationality.
I'm not following at the moment. You seem to be drawing a distinction between the fact that there had been a domestic law finding about the regulations which weren't appealed, and I can't see the relevance of that to the paragraph that you've just read out. I'm not following the link between the two.
Well, in my submission, my lord, the High Court considered them, or Mr Justice Ouseley considered that he was able, notwithstanding the context, notwithstanding the rationale for the provisions in the regulations, was able to determine that they were unlawful, having regard to rationality. And while proportionality is a different test, of course, nevertheless, if the regulations are irrational, it's difficult to see how they could be proportionate.
But there were different regulations. I'm not following the link. It doesn't tell us anything about these regulations. It may or may not tell us something about those regulations and the ordering for those regulations, but I don't see the read across. We've got to look at these regulations, which are different regulations.
No, they're the same regulations that were in issue below. I mean, Mr Justice Ouseley found that the original provisions
governing the ordering so far as they affected non-parental caring arrangements.
And in due course, adoptions were also
adoptions, but he didn't do a review, or he didn't really do rationale in relation to the non-conceptually conceived children, did he?
He didn't,
No.
but certainly we learn from the judgment of Mr Justice Ouseley that the randomness of the operation of the provision was a factor in determining, or was the factor, in essence, of determining the rationality
of the regulations governing parental arrangements and adoption.
Yes, and that rationality argument, we submit, applies equally here, where one is ultimately concerned with when was the woman raped so as to result in conception of a child she didn't choose to have at a time she didn't choose to have it. So we say the same arguments can be transposed, and of course the 2013 regulations as amended were the same regulations as applicable here. And as we say in our skeleton argument, and indeed below, we say that exception having been made in the case of kinship, relationships or adoption, that having been made, so it ought to have been made in our case, because the vice is in essence the same. There's a randomness, there's an unfairness, and as we've also said, although this didn't find favour below, but we've also said it must be obvious that there is a greater risk that a child will go into care if they have been conceived as a result of rape. But I'm mindful that I'm appearing in front of somebody who will have a much better idea.
Well, I think you concede that there isn't powerful research evidence on that. Whilst it might be a reasonable approach, it's not something that's supported by evidence, I don't think.
That's right. It wasn't supported by evidence, and so we weren't able to place any great weight on that. So that was the Supreme Court, not it was justified, highly contested in primary legislation, and we say that's material. Highly contested, went through full parliamentary scrutiny at a time when it was known to be highly controversial. So extensive scrutiny, not the territory we're in here. And if I can move on then, so that's the context. Mr. Justice Ouseley and irrationality, finding against the claimants in respect of the application of the Convention rights, no appeal against rationality, and in due course the Supreme Court held that the Convention rights were in fact engaged, albeit that the discrimination found was justified. If I can take you now to these cases, first of all, if I can take you to the judgment at tab 8 of the core bundle and ask you please to look at page 77, 76 and 77. You will see the facts summarised. Paragraph 14, first of all, you'll see the context, which perhaps needs no explaining. Chilling accounts of appalling domestic abuse, vulnerable girls, barely out of childhood, toxic relationships, in which their personal, reproductive and family autonomy is acutely compromised by physical, sexual and emotional violence and controlling perpetrators. So very vulnerable women and girls at times. And then just if I can ask you to look at the chronology, so to speak, in LMN, 16 years old when she found herself in an abusive relationship with her first partner, she moved in very quickly. After her first child was born, she was violently assaulted by him. Social services became involved. That subsisted for 12 years. 3 further children were born in circumstances in which pregnancies were not planned, fled the relationship, ultimately arrested and imprisoned. She fell into a second violent relationship, a controlling relationship with Y. So she had 4 children from the first, and then with Y, short-lived, the local authority was sufficiently concerned for the welfare of her 4 children that it removed them from the household, initially placing them with the birth father, and 6 months later took them into care. So she was then pregnant with her 5th child, her 4 children being taken into care. Following the relationship ending with Y, again fell into a 3rd violent and controlling relationship with Z, fell pregnant with her 6th child, so her youngest child. She contemplated termination, but he wouldn't permit it. Within a year of the 6th child being born, the local authority made arrangements for her 2nd child to return from care to live with her. So just pausing there, she had 2 children at home with her, the 6th child, the youngest, and the 2nd child, 2nd eldest. Anna, you'll see it, not her real name, I should say, but Anna is the 2nd child. So youngest and nearly the eldest, 2nd eldest.
So the 2nd child was moved back from care to the mother's care, and the 6th child always lived with the mother.
That's right.
Yeah.
That's right. So that's how it worked. And of course, because as I've indicated, one's concerned with date of birth, not date of responsibility, for example, then Anna, 2nd child, is counted as the 1st child for the purposes of benefits. In paragraph 18, her entitlement was then calculated on the basis that the child element would be paid in respect of the first 2 in age of the children living with her, her 2nd child and fifth child, those were already living with her, I should say, but the child element would not be paid in respect of the youngest because it couldn't be established that she fell within the exception. No challenge to that, although that appears to have been later. A challenge is to the regulation that produced the result that for a three-child benefit family, no additional child benefit is paid, even though the first two were non-consensual conceptions. So she has her two children. Anna counts as the second eldest, non-consensual, so in due course is Zed's child, found to be so, but the two of them already live in the home, fifth and sixth, and Anna, being the eldest, although she's non-consensual and hasn't been at home, hasn't been responsible, the mother hasn't been responsible for her, that doesn't matter.
So the second child was the non-consensual child, and the fifth and sixth were consensual children.
No,
They're all non-consensual. Why doesn't? But I thought there was an exception for a child born.
there is. Sorry, the last child
Can't have been non-consensual. Must have been consensual.
Yeah.
Or does she benefit from the exception?
Yeah.
Sorry, I think there was an issue, wasn't there? With she later was recognised as being non-consensual.
That's right.
So there's a period during which she wasn't subject to the exception, but then she was. I think we might have taken the point on that being rendering the case academic sometime in the past, and we've absolutely abandoned that.
Yeah.
So yes, it's about the period before she was recognised as having been the product of a coercive and controlling relationship.
Once you recognise that the sixth child was a non-consensual child, the child element was payable for that.
Yes.
But moving.
Have you paid it back?
No, because my lord will be familiar with the way the benefit system works and the change of circumstances notifications and the way that everything is prospective. So these exceptions apply when they're applied for.
Right, but in a sense, for this claimant, whose circumstances I know are truly tragic, it's not helpful because the problem isn't that she's not getting it for a third charge who would get it, but there's been some other problem in the rules, isn't there? Nothing to do with the exceptions.
Well, no, it's the rules that prohibit her being awarded benefit in respect of the third child. There may be separate rules about whether or not the Secretary of State can make that good by a payment, but certainly it's the rules that create the problem in the first instance, not the absence of the facility to pay. Certainly that's certainly not the way it's been argued.
The point, as I understand it, is that there was a period at which child number 3 was not recognised as non-consensual, and therefore, for that period, she wasn't able to get this benefit, and that can't be put right retrospectively. So one needs to be able to determine whether the rules were legal at the time. That, as I understand it, is the position.
Precisely. And then at EFG, at paragraph 19, page 77, 15, when she left home, fell into a violent relationship with W, became pregnant with this child. 10 days after the child was born, W raped her, and then there was a pattern of repeated rape and controlling behaviour. She became pregnant again, and there were 2 deaths, very, very tragically. And then at paragraph 21, twice 2 further pregnancies, W forced her to terminate the pregnancies. And then 2 children followed after that, a daughter and a son, each conceived by rape after a particularly violent attack, and W went on to kill himself. She was able to move on to a new consensual relationship. An unplanned pregnancy ensued, but they proceeded on the basis that her partner was reassuring that he'd be able to support them and their 3 children, but he lost his job, and so she updated her universal credit claim. Here she was given some misinformation about that. A son was followed by a daughter, another unplanned pregnancy. She was then told about the rule. Again, she doesn't challenge in these proceedings that particular sequence of events. She accepts that. Her challenge is to the regulation that produced the result that a family comprising two children conceived of rape as a result of rape by two unplanned children in a consensual relationship has no exception.
And this creates a clear example of the problem without the complications of retrospective realisation she should have been entitled to it all along.
Precisely.
This is the clear example in any event.
Precisely.
Yeah.
Precisely. So there we are. So she has two children born as a result of non-consensual conception, and the two children she chooses to have with the partner she chooses to have at the time she wishes to have them, no benefit payable for that.
And your point is that if it was the other way round, then she'd get payment for all four.
Precisely. And that's, as I observed earlier, perhaps not, I didn't articulate it terribly well, but there is a degree of randomness in this. It just depends on which child is the result of non-consensual conception. That is where those children are born in terms of order. And you've seen what we say about that. But those are the brief facts. And if I can just take you to the judgment insofar as the judge directs herself in relation to the claims and the legal tests. If I can ask you please to turn to page 79. Paragraph 29, so towards the bottom of the page, identifies Article 14, and then over the page, paragraph 31 onwards, identifies those matters that have to be shown if a violation of Article 14 is to be made out. Firstly, that the complaint matter relates to a complaint relates to a matter that falls within the ambit of one of the substantive rights, and I know your lordships and your ladyship will be familiar with that, and finds Article 8 and Article 1, Protocol 1, and then status, and importantly, I'll come back to status because the judge finds that this is a suspect class. And thirdly, must identify a difference in treatment in an analogous or relevantly similar situation, maybe direct or indirect, fliminous discrimination, which is in essence indirect. Same treatment needs to be an adjustment because their situation is different, and it was put and is put that one can't compare a first and second and third child consensually conceived with that of a non-consensual conception child. I would want to describe them in those terms. But fourth, the measure will be unlawfully discriminatory only if there's no objective and reasonable justification. And the four Bank Mellett criteria or questions are identified there, well known, and no dispute about those. So the judge sets out the test that she has to apply, and then at paragraph 1, as I mentioned, I'll come back to status.
So you don't take issue with the summary of the law, the legal test, as set out there?
No, it's the application.
It's the application.
It's the application. So, I mean, in short summary, we say that having set out the law, she fails to apply.
Yes.
In summary. So if one looks, please, at paragraph 38 at page 81, starting at 35, you'll see that it was argued on behalf of the claimants that the status relied upon, that is what was the basis of the discrimination, is mothers of non-consensually conceived children. There was a dispute about that, but in the event the judge accepted the way that the claimants put it. and also identified that that was a suspect or highly suspicious, as it was described. Paragraph 38, bottom four lines. It is therefore, in my judgment, not only a legitimate status, that mothers of non-consensually conceived children, but one where if discrimination is identified, it will be a highly suspicious nature in the sense to be understood from the case law. That is one heightening the intensity of review. My lord, did I beg your pardon, I thought I heard a question. Because it's a suspect class, suspect group, high degree of scrutiny required. No, I should say no challenge to that.
But if it's Schwidler, don't we have to do it all again ourselves?
Well, that's what we will be saying.
So do we have to do this again, or do we accept this?
Well, you can do what we're looking at is proportionality in terms of Schwidler, and certainly the status and whether it's heightened or not review will be material to that question. Of course, it's disputed. I mean, we say it's for this court to determine proportionality, but if the court is against us on that, and the court takes the view that it's a review standard only, then of course these matters...
No, my question is different. If you're right and it's Schwidler, it's not just Schwidler in relation to proportionality, is it? Isn't it Schwidler in relation to all of it? We have to do the whole 4 questions ourselves. Or is it just proportionality?
Just proportionality.
Just proportionality, okay.
I mean, just proportionality. I don't say that that means status is immaterial, because of course the weight to be afforded that is greater if it's a suspect class. So I don't say it's immaterial, but I do say we're concerned with proportionality and balance.
Your position is that the judge got it right for the reasons that she gave, and that's the launch pad for you to claim that she got the proportionality test wrong.
Precisely. So she recognised it was heightened scrutiny, and then in very short summary doesn't apply that analysis. Indeed, we would say it doesn't address proportionality at all, but in any event certainly doesn't weight the class issue, the status issue. It doesn't subject it to heightened scrutiny. So that was the status point, highly material to the weight to be afforded the interests of the claimants. And then at page 81, paragraph 41, she summarises the page 81, paragraph 41, summarises the forms of discrimination relied upon. First, they object that the regulations treat universal credit recipients who are mothers of NCC children the same as UC recipients who are mothers of consensually conceived children, though their circumstances are different. So the theliminous contention. And then over the page, so identifying why their situations aren't comparable so far as the claimant's concerned, says top of the page, first sentence, but the regulation elsewhere expressly recognise that's a material difference between the two classes. In the first place, there is an exception for the limitation for the mother of a child, a third or subsequent child who is non-consensually conceived. So recognising a distinction that the judge accepts between the two classes of children, already it's the ordering that's the problem, and of choice about bringing the child into a family, but mothers of first or second children, first or second NCC children did not choose to do so. Further, the nature and quality of the choice available is distinctly and relevantly different. So in other words, it was argued, as is recorded here, argued by the claimants, that in choosing a third and fourth child, when your first two are the product of non-consensual conception, that decision is qualitatively different from having a third and fourth child where the first two are consensually conceived. So there's 4 consensually conceived children. It's very different where your first two are non-consensually conceived. The only choice you have. And then at paragraph 82, you'll see the second way it was put. They object that the regulations treat universal credit recipients who are mothers of NCC children differently for those who've adopted or kinship carers. And then at paragraph 45, there is the care point, and my lords already made an observation in relation to that, and I won't trouble you with that. Identify the forms of discrimination relied upon, and then goes down at paragraph 53 to identify where that took the judge, and deals in particular the question of comparability, which, as your lordships and your ladyship will recall, is regularly a problem, and which the courts often say, let's not focus on comparability, go straight to justification, because if they're not comparable, the difference is likely to be justified. But identifies the difficulty at paragraph 53 of being satisfied of a clear analogue remains problematic, because without precise identification of a properly comparable difference in treatment, hard to be confident that the analysis is appropriate. But in these circumstances, and again putting the place at its highest, proceed on the basis that it's a Claimants challenge, and that's at the heart of their complaints, and goes through. So decides in due course, as you see in the last two lines, that justification needs to be gone through.
So she accepts that both groups, the biological mothers who don't have NCC children and the adopter stroke non-parental carers, the comparison with each of those two groups is a legitimate comparison. It involves comparing the claimants with two separate groups which are in materially analogous positions or are not, and it's liminos. But you've got to compare the effect on both.
Yes. She identifies at paragraph 53 sometimes the complexity of doing that, but concludes in any event that it is possible to make a comparison, and it is therefore a matter of justification. So the first elements, the Article 14 analysis, have been satisfied, and it's then on to justification.
She's taking the Thluminos challenge as really the lead, isn't she?
Yes.
Because she recognises the difficulties with the direct discrimination by finding the analogy with adopted children. And is she not saying, well, I'm going to look at it through Thluminos perspective and then check it against the other way of looking at it?
Precisely.
Yes.
And so, as I read the judgment, my lady, she's identifying the fact that comparisons can sometimes be difficult, but at its highest,
yes,
the case takes us through a Thluminos lens to discrimination, and standing back, as she described it, considering it in the round, including the adoption and non-parental carers, look to justification.
It's certainly, I can sympathise with her because it's easier to look at it through the Thluminos lens.
Especially in relation to the care issue.
Yes. Insofar as Article 14 can ever be described as easy, it's a lot
yes.
more straightforward, let's put it that way, to look at it that way, because
Yes.
you've got a direct comparator.
Precisely. And then, as to proportionality, she deals with a legitimate aim. There's no dispute in relation to that,
Yeah.
which is essentially, as it was in SC, fairness and economic imperatives. And then, if I can take you please to paragraph 69. concludes that there is a rational relationship between the regulations and the aims, that is fairness and economic imperative. And then
And you complain about her analysis in 69.
no. No, my lords, I'm just checking with Mr. Royston. The identifies the aims of the legislation, and then concludes that the caring and adoption is consistent with the aims identified because they save money, and therefore they meet both fairness and economy. And so the court concludes that that is not so here. It's not that we say she isn't entitled to find that. It's just where she goes with it. So yes, justified for those two, consistent with the aims and fairness, still requires that the judge answer the questions in relation to these claimants. And at paragraph 71, forgive me, paragraph 81, she deals with proportionality, which is the central issue, of course. And at paragraph 81, page 91, I turn finally to the overall proportionality balance. Considerable case law, Strasbourg and UK, on the correct approach, reviewed in SC, and I've studied that close attention, sophisticated analysis, and gratefully accept the up-to-date assistance it provides, and then sets out the Supreme Court's consideration, Lord Reed's consideration of the position, the jurisprudence in relation to the ECHR, and it deals, Lord Reed addresses paragraph 142 under paragraph 82. I didn't take you back to SC. We see paragraph 142, and you'll recall that the Lord Reed is dealing at that stage with the manifestly without reasonable foundation test, which has been at times very controversial. So manifestly without reasonable foundation, that's the threshold for determining proportionality. Is it manifestly without reasonable foundation? He explores that, and then if I can take you over the page at 92, deals with, the third line down, as I've explained, there's not a mechanical rule that the judgment of the domestic authorities will be respected unless it's manifestly without reasonable foundation. So pausing there had been authority in the domestic court suggesting that the test in benefits cases would be manifestly without reasonable foundation. Lord Reed states that the position is more nuanced than that. So general principle, national authorities enjoy a wide margin of appreciation in the field of welfare benefits and pensions. And that's an important element of the court's approach. But its application in particular facts can be greatly affected by other principles which may be relevant. In the context of Article 14, the fact that the difference in treatment is based on a suspect ground is particularly significant. And I flag that, of course, because that's the territory we're in here. The cases indicate a general need for strict scrutiny focused on the requirement for very weighty reasons where the difference in treatment is based on suspect grounds such as sex and so on, unless the issue concerns the timing of reform designed to address historical inequalities. That's a line of case law I needn't trouble you with, my lords and my ladies. And then at paragraph 83, paragraph 158, under paragraph 83, deals with what might be described as the nuance required. Low intensity of review is generally appropriate, other things being equal in cases concerned with judgments of social and economic policy in the field of welfare benefits. So the judgment of the executive or legislature will generally be respected unless it's manifestly without reasonable foundation. Nevertheless, the intensity of the court's scrutiny can be influenced by a wide range of factors, depending on the circumstances, as it would if it was applying domestic test of reasonableness. In particular, very weighty reasons will usually have to be shown, and the intensity of review will usually be correspondingly high if a difference in treatment on a suspect ground is to be justified. Other factors can sometimes lower the intensity of review, even where a suspect ground is an issue. Equally, even where there's no suspect ground, there may be factors which call for stricter scrutiny. So is, again, considering the nuance, and then if I can take you to paragraph 159, for my purposes, well, I'll perhaps read it all, because I don't take it out a sentence. It's therefore important to avoid a mechanical approach, simply based on the categorisation of the ground. Or flexible approach will give appropriate respect to the assessment of democratically accountable institutions, but take proper account of other factors. Courts should generally be very slow to intervene in cases of social and economic policy such as housing and social security. But as a general rule, differential treatment on grounds such as sex or race nevertheless require cogent justification. So we say, even in the context of a benefits case where suspect, particularly highly suspect like sex and race characteristics are concerned, cogent justification, and we say we're in that territory here. And then at paragraph 86.
Well, 85, she says, in fact, this is a situation where even though it was a suspect ground, the primary legislation was found to be justifiable, even though it had a disparate impact on women.
That's absolutely right, my lord, in a context where it was primary legislation. So there was another factor in the balance, in the nuance, so to speak, and as Lord Reid makes clear, that is a particular factor because it brings with it a greater degree of democratic legitimacy. So that is a factor, but certainly the fact that he concluded, or the fact the court concluded, forgive me, that it was justified, even on suspect grounds, must take account of that, and we are not in that territory here. We're in, we're looking at regulation, subordinate legislation, not primary legislation. And so then if I can take you please to paragraph
Well, she says in 86, the judge, that there had been a degree of parliamentary scrutiny. They were subject to the affirmative resolution, not just the negative one. Parliament had approved them. It's obviously not legislation. There aren't 3 readings and so on, but there is the affirmative resolution in Parliament.
That is still, my lord, as your lordship knows, attracts a very lower degree. It doesn't. Affirmative procedure does not attract the same degree of scrutiny.
No, I accept that. I just said that, but it's still a high degree of public scrutiny by the part of the elected legislature. It's not something Parliament doesn't know about. A minister would have accountability anyway, but when it's negative, it's got at least to be laid before Parliament. But when it's affirmative, they have to vote for it, don't they?
They have to affirm it, yes. But it doesn't carry with it the same degree of scrutiny, parliamentary scrutiny, as primary legislation. And there is great emphasis played, or there's great emphasis in SC about the fact that it was primary legislation and about the fact it was particularly controversial, so was subject to a great deal of scrutiny in the democratic institutions. And as I've said, we're not in that territory, even with an affirmative resolution procedure. Does it say that in the judgment? Mr. Royston is just reminding me that the original regulations were affirmative, the amendments were negative. It may be if your lordships want to, and ladyship want to see that, I can get it to you.
Yeah.
So sections 42 and 43 of the Act identifies the procedures so far as the regulations are concerned, and the original regulations have to be by affirmative resolutions, amendments negative.
And we're dealing with the ZA amendment, was it, that you're challenging? And was it the ZA amendment that was, no, it wasn't
Well, no,
ZA?
it's ZA, but it's also 24A and B, because of course the original regulations, there wasn't a two-child limit. And then the two-child limit was introduced by later amendment.
And they were affirmative?
No, they were negative.
They were negative?
Because the original... Okay, well, I'll get the answer to that because I'm getting different messages from behind.
Quite important to have it
Yes,
accurate.
no, I will certainly do that. My recollection, the reading was the original were affirmative, the amendments were negative, but I'm getting a different message from behind and I certainly don't want to mislead you. So, as I've indicated in the event, I've made the point about paragraph 86. It's a very different standard of review to to that which would be applicable in the case of primary legislation. And then at paragraph, just trying to make sure I don't take you to anything I don't need to. Then at paragraph 88, notes that the regulations operate in the field of social and economic policy. That, of course, is relevant, as Lord Reid identified. That is a factor. And then at the bottom of that paragraph over the page, she notes 2, 4, 5 lines up from the bottom. These are deliberate policy choices made and tested in the arena of public and parliamentary opinion. Limitation of the exceptions is part of the definition of the two-child limitation. Scheme of the exceptions, deliberately made and not made, internally logical and reconcilable by the legitimate aims, fairness and economy. So there's no doubt that weight is given to the fact that there has been some scrutiny and that they form part of a wider scheme, and we don't say that that isn't a factor that ought to be taken into account. And then at paragraph 89, all of these are considerations which inevitably demand from the court a high level of respect for and correspondingly restrained degree of scrutiny for the measure in question. But in Article 14, status of mothers of NCC children requires intense scrutiny so far as the comparative treatment of them is concerned. So strict scrutiny, but some degree, or noting that some degree of restraint is required. So picking up on Lord Reid's points. And then at paragraph 99, thank you, straight there. Paragraph, extracting a paragraph 98 of the judgment, paragraphs 208 to 209 of Lord Reid in C, in which he concludes at the very end of that extract, paragraph 209, no basis consistent with the separation of powers under our Constitution on which the courts could properly overturn Parliament's judgment that the measure was an appropriate means of achieving its aims. And then the judge below says, in my judgment, the limited qualification of the primary legislation by the regulations challenged in this case cannot ultimately lead to any different place The challenge engages directly the issue of balance between the interests of mothers of NCC children and those children themselves in receiving extra financial support, and the interest of the community of expecting all mothers with parental responsibility to discharge the responsibility and manage choices within the overall economic framework, and does not unfairly disadvantage unsupported families. Competition between two socio-economic versions about where fair and reasonable balance can be struck, and the court cannot legitimately arbitrate where they have been settled in contested political processes with which a court can legitimately interfere. We say that's wrong. It was the judge's job to undertake the balancing exercise, having regard to what we say is a very serious adverse effect on women who have been subject to extreme violence and have lost or would lose, were they to not have other children because of the impact on their benefits, would lose the opportunity to enjoy any reproductive autonomy. And there is no weighing of that in there. And of course the issue in the two-child benefit case at SC was the primary legislation about the issue of principle. Was a cap permissible, notwithstanding the disadvantageous effect on women and children? We have here a discrete additional factor that these are women who have been deprived of reproductive autonomy, and were they to not have children because of an absence of benefit entitlement, then they will have lost any chance of having children with a person they want, at the time they want, and by consent in the context of a loving relationship. That is very severe impact indeed, we say, and requires high-level scrutiny. Cannot be abrogated in the way that the judge has done, we say. And then at paragraph 103 onwards, essentially the same thing. We say there is no engagement with the balancing exercise, and if we turn to page 100, paragraph 106, start at the top of the page, I'm bound to apply the principle of proportionality and exercise my evaluative role in relation to it in a way that's consistent with the separation of powers under our Constitution. I'm rightly compelled to distinguish between moral, political or economic arguments about fairness and legal arguments about discrimination. I would have been able to find a legal basis to intervene as the claimants asked me to do. I would have had to find a legal basis on which a court could properly overturn the judgment the Parliament has endorsed that not accepting mothers of NCC children from the two-child benefit was an appropriate means of achieving the aims. So no balancing of the interests of the women and the impact on them. And then paragraph 107, I've not been able to do so. My judgment, the question of justification, again, ultimately resolves itself into a question of whether or not the solution we have was the right policy decision, whether or not it amounts to wise legislation, and so on. And then at paragraph 108, I've looked carefully for, but have not been able to find a legal basis for reaching any conclusion to opposing policy arguments about where the balance between the collective and the individual be struck are in contention. And we say throughout all of this, there's no regard to the particular complaint here and its impact on a very, very, very vulnerable class of women. As lifted in essence, what Lord Reid says about the need to take account of the importance the democratic institutions which had come to the judgments that they did, and that the Supreme Court, in essence, couldn't second guess that, but that's not, to say, the position here. As to the court's function, my lord's already picked up Schvidler. And if I can ask you to turn to page tab 17 of the authorities bundle. This is a case completely outside of the issues we're concerned with here, but concerned the question whether or not a court, an appellate court, should undertake a proportionality analysis itself, where complaint was made about the conclusion on proportionality, or whether it's a review exercise. Tab 17, page 359, it concerned the application of a sanctions regime following the Russian-Ukraine war, the Russian assault on Ukraine. Needn't trouble the court with that, but it was contended it breached Article A1P1, and at page 410, at paragraph 142 to 144, it's set, I don't propose to read it to you, but simply to observe that there have been two approaches to an appellate court's role in relation to proportionality. That is it fresh assessment or is it review? And then at paragraph 143, each approach is justified in the proper context. The review approach puts emphasis on the dispute resolution effect of the first instance judgment, on a determination of the facts, and militates against repetition of arguments going up through the system. So no second bite of the cherry. In deciding which issues should be open for debate in the higher courts, it's well recognised there's a need to ensure that the limited resources are employed in a focused way. And just picking up, if I may, they're concerned there with dispute resolution, and in my submission that's a reference to individual cases rather than a challenge to a regulatory regime. And we're here concerned with a regulatory regime, regulations, and the first case in which this matter has come before the court. 144, the fresh determination approach is appropriate where it's important that the appellate court should give its own opinion about proportionality of a measure and its compatibility with the convention rights, rather than defer to the first instance judge. This is likely to be an important consideration in cases where the decision will provide guidance for other cases, or where the subject matter has major social or political significance, so the public will rightly expect senior judges to undertake that exercise. Now, we say we're on that side of the line. It's not merely an individual complaint, it's a challenge to regulations. There haven't been any cases on this issue hitherto, and it's a case engaging major social significance, perhaps political too, but from our client's perspective, social. That is protection of the rights of very, very vulnerable women subject to male violence over a prolonged period of time, with the effect that their reproductive autonomy is seriously interfered with. So we're on that side of the territory. There is then paragraph 147 onwards a very detailed account or a section. I would invite you to read it. I think everybody wants you to read it. But again, if I can just emphasise, it picks out again this point about dispute resolution and whether or not it only affects persons in the proceedings rather than having broader reach. So I'd invite you to take account of that. I invite you to read it, but simply to state that there have been historically two approaches. Review may be appropriate in some cases, having regard to the need to stop everybody coming up and down, but where it's a first case, where it engages a matter, serious social policy, and where it engages more than one person, it's right that we say the appellate court should start afresh. Even if we say we're wrong about that, we say even on a review analysis, the court will have to undertake that assessment itself, because as I've sought to identify, the judge didn't undertake that assessment herself in any event, certainly not properly. Those are the case law, and just in relation to the submissions on the proportionality point, and I can take them briefly, they're in the skeleton, I needn't take you through the skeleton, but just to pick up on some points, mindful that this is a suspect class, there is two particular provision made in the Convention on the Elimination of Discrimination Against Women, a UN convention, not binding domestically, of course, but nevertheless, we say one of those provisions, one of those conventions or treaties that will help a court inform.
And there's quite a lot of discussion about that in SC as well, because we can't give effect to international treaties that haven't been incorporated. They may be relevant to interpretation of the provisions of the Convention for the Protection of Human Rights, but we haven't seen any way in which it is said that it's relevant to that. So how is it relevant to the question of whether or not these particular regulations are justified?
Certainly it was argued below that and it's argued here, and Opus, we have the skeleton arguments here, so I can show you in due course. It's the Claimants case that in understanding the meaning to be afforded Article 14 and how to engage with proportionality and suspect class, the Convention on the Elimination of Discrimination Against Women is a factor that can had regard to, because it helps inform Article 14, as the European Court of Human Rights has said more than once. We have the skeleton arguments in the bundle. We don't have the case. Opus was an example. Your Lordship may be familiar with that. I don't know. It was a domestic violence case, failure to protect, only an example, but a case where the convention was referred to by the European Court for the purposes of exploring and understanding Article 14.
But I thought this was really all about an application case to these particular regulations. I'm not immediately sure that the Convention assists on the application, unless you're saying that Article 14 must be interpreted in a particular way as to prevent any arguments here about whether or not the application was unlawful. Otherwise, we are just using conventions, which SC says we're not supposed to do.
Well, it's our submission that it is a relevant context for understanding the weight that should be afforded in a suspect class case, because an international convention makes clear that reproductive autonomy has in particular importance for discrimination, and since that convention is regularly referred to by the European Court, then we're entitled to invite the court to have regard to it too.
Do we have the convention here?
Yes. I can ask you please to turn to tab 21. Tab 21, this is the convention, and you'll see the preambles and so on. I need to trouble you with. 585 Part 1 Article 1 identifies the meaning of discrimination against women, any distinction, exclusion or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of their marital status, on a basis of equality between men and women, human rights and fundamental freedoms. It's a wide concept of discrimination against women, including the enjoyment or exercise on on a basis of equality of human rights and fundamental freedoms.
But in this case, we're not dealing with cases of discrimination against women per se. We're dealing with comparisons between women with non-consensual children and women without non-consensual children. So you've got two lots of women that you're comparing, not women with men.
Well, I just want to take you to one of the articles that we drew on in particular, and that's Article 16, page 589. This is one of the obligations imposed on states. State parties shall take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations, and in particular shall ensure on a basis of equality of men and women, E, the same rights to decide freely and responsibly on the number and spacing of their children and to have access to the information education needs to enable them to access those rights.
But is that not saying the same rights as men?
Saying the same rights as men, yes. But the point I invite the court to take from this is the significance that a non-discrimination convention gives to the importance of reproductive autonomy.
Well, you say that. I mean, it's a phrase that attracts attention, reproductive autonomy. But what are you saying in E here? The same rights to decide freely and responsibly on the number and spacing of their children, without wanting to sound in any way harsh, after they'd finished the violent relationships, when they finally got away from the abusers and the violent men, and they had a different partner who was not abusing them and was not violent to them, there's nothing to deal with the question there about whether or not they could or couldn't have children. There's not a policy or a restriction on the number of children they're allowed to have as you have in some countries. So when you get to that stage, I don't quite see where there isn't a right to decide freely and responsibly on the number and spacing. What you really want to say is, and the state should provide the additional element of childcare.
That's the point.
Yes.
It's an economic imperative rather than a sociological one.
Well, yes, but in determining the weight to be afforded that, it has been our submission. I can't say any I don't think it will get any better with repetition. But we say that international law recognises as part of a gender equality convention that spacing and reproductive autonomy is an important value, an important right. And simply to say, and I won't say anything else on this, but simply to say, we say that prohibiting or depriving a woman of benefit for a third child because her first two were non-consensually conceived does impact on reproductive autonomy, and the convention makes clear that that's an important factor.
Well, looking at this, again, without wanting to be difficult, but we have to, I mean, if it's relevant, then we have to look at it. The same rights to decide freely and responsibly, well, that's not something that's impacted on, and have access to the information, education, and means to enable them to exercise those rights. Means to enable them, I suppose, might carry economic considerations, but it would be rare to find an interpretation of international convention that says the state must provide the economic means, and indeed I doubt that the child element of universal credit would be enough to enable them to have a child. It's an additional element. They'll get the housing and they'll get everything else, but even then I suspect it's not going to be enough. So are you really saying that this convention requires the provision of state welfare benefits to women?
No, it's a convention which identifies a number of rights that the international state bodies have decided is important. And your law, it doesn't any more than the convention requires a state to do anything, in particular here. It requires a proportionality analysis to be undertaken if the convention rights are engaged. And we say, when you're looking at proportionality in relation to the convention rights, you can see the weight, I describe it as reproductive autonomy for shorthand, the weight that attaches to that in a gender equality convention. And whilst your lordship says same rights to decide freely and responsibly, well, that is impaired in the case of a woman who is on benefits if she knows that her third and only consensually conceived child will not be entitled to benefit, or she will not be entitled to benefit in respect of that child.
Why isn't it exactly the same if the first two are consensual? Because in either case, the woman realises that bringing the third child into the world is going to have an impact economically on her position to bring that child up.
Well, we're looking at this case and this particular.
Yes, I know we are, but I'm doing a Thelimenos
Yeah.
comparison at the moment, and I'm just wondering why everything you've just said doesn't equally apply to a woman who's had two consensual children and would like to have a third.
Well, as I think my Lord Justice Lewis alluded to, these don't guarantee absolute rights.
No.
What we are concerned with here is a situation where there is a deprivation of all reproductive autonomy. So, whereas the meaningful reproductive autonomy, I should say.
Well, yeah, that's what I was pressing you on, Miss Monaghan, because I'm not sure that it is a deprivation of reproductive autonomy at all in the real sense.
Well, it is in this sense. A woman who is reliant on benefits is, which of course is at the level of just subsistence, or not quite subsistence, but certainly there's going to be little spare cash, and that's an understatement, is going to be impacted by the knowledge that she will not be entitled to benefit for the third child, and that may well deter her from having a third child, and that's in the case of non-consensual as well as consensual conception. But the impact on a woman who has not had a single child consensually is more severe, because she has been deprived of any choice unless she's going to descend into poverty.
But she hasn't been deprived of choice, to be perfectly fair about it. She's exercised the choice as this happens in this case, and she's had another child. The question is, should you get the child element for the child? It's not stopped the exercise of reproductive autonomy, as you wish to call it, for these two women. It may affect other women, and that may be your point, but it seems a long way from deprivation of meaningful reproductive autonomy to say you won't get a state benefit of the child element for the universal credit. Whether that is what this treaty is about, and whether we can interpret this treaty as helping us interpret the European Convention and in some way relevant to the application of the Convention to the facts. It seems a very long way away from what we're supposed to be doing after SC.
Well, I
Would
can't
you say
put the point
we should?
Better, and I'm mindful of the time, but I'm not sure I can put it.
Your point is that it's an important factor and it ought to colour the way in which we looked at.
Precisely.
And it would be the same with or without this convention, I suspect, because it's the same thing. We want to stop and think about the impact on the women.
Well, then maybe that I don't need it.
Yeah.
Maybe you will all be with me, my lord, and I wouldn't have needed it. But I ought not to take any chances. We've set out in the skeleton the facts and matters we rely upon so far as justification is concerned. But in essence, we say that no weight was given by the judge below to the matters that fall in the balance, so to speak, on our side. No particular weight in particular to the specifically adverse impact on women with NCC children. I think I've probably made all the points I've gone along, but may I just take one moment to go through my notes and check that I neither repeat nor forget. There's one final point, and that is the observation or the finding that the learned judge found below in relation to parental responsibility. Now, we say there's no basis for a finding of the sort that the judge made, and if I can take you to that, which is at the core bundle, paragraph 96, page 95.
Is this your ground 3? Yeah.
Yes, ground 3.
Yeah.
So ground 1 and 2 essentially have merged, have collapsed into each
Can
other.
we come back to ground 3 in just a moment? If we're with you on ground 1, that is Schwidler, we're going to do it ourselves anyway. And then ground 2 is without any disrespect to the judge below irrelevant, not material.
Not material in terms of the balance.
No, if we do it ourselves, if we accept your argument
Yes.
that after Schwidler, this is one of those cases where the Court of Appeal must do it itself.
Yes.
And you're either right on one or you're wrong. It either is or it isn't justified, and we'll have to decide
Yes.
doing Schwidler. But if we decide to do Schwidler, using shorthand, to say to carry out afresh the proportionality assessment, then ground 2 is frankly
Yes.
immaterial, isn't it?
Yes.
Yeah.
Yeah.
And it's also immaterial if we say, no, she can do it, but she's got to do it right and she's done it wrong, we'd have to do it ourselves anyway.
Yes.
So it's only if she and she alone does it and she's got it right that we get to ground 2.
Yes.
Yeah. So really it's right or wrong. Yes. Yeah. So you wanted to do ground 3, which is separate.
Yes, it's a very discrete point, and this is on the judge's findings in relation to parental responsibility. And if we look at, please, paragraph 96, starting at 95, just so the context is clear, the nature of the challenge with which the court is being asked to grapple in this case, this is the nature of it, that is an entitlement to rights to be conferred. That is the nature of the challenge which is the court's being asked to grapple in this case. Question for me is whether these kinds of arguments from fairness having been and continuing to be conducted by government and parliaments over the years, the law protecting individuals from unjustifiable discrimination in rights to private and family life and to financial property, forces a different outcome and places the outcome delivered by the regulations definitively outside the scope of the choices they were legally permitted to make. Is this a matter the law can resolve at all? Really just repeating the observations I've already made. That's a matter she should have engaged with respect. Can the law require the regulations to be amended so mothers of NCC children who are universal credit recipients must be paid per child? And then it says, this would of course reintroduce an economic disparity with self-supporting families, that is those not on universal credit, in an identical situation, which is important, legitimate and democratically validated aim, imposes selective pressure on public spending. And then, next sentence, it would also touch on something very fundamental, the nature and law of parental responsibility. Both mothers have legal rights and responsibilities in relation to their children, however conceived and without distinguishing between them. The equal aim echoes something very basic indeed about family life. And you'll recall perhaps that the government had said if we need to ensure or we need to promote the value that all of the children are treated equally. So we shouldn't ignore those children for the two-child benefit cap simply because they are born of rape. You have your two children and you now have your children and they are just as if they were consensually conceived. And so this comes into legal rights and responsibilities, and we say there's nothing, that's simply not so. There's nothing here that would point to any fundamental impact of the sort anticipated, and so it's a point that goes nowhere in this respect.
Sorry, just so I've understood the submission, you're saying that if you win, this is not something that is in some way going to devalue or downgrade the importance of a child, irrespective of whether he or she was the subject of non-exceptional conception, that this will not strike and say you're a lesser child than the later one. That's your submission, is it?
Yes, and that's
Yeah.
just with kinship
Yeah.
arrangements or adoption arrangements. Nobody's saying, well, the first two don't matter so much, we wouldn't get benefits for them, but we can for the adopted child.
So I've written down the submissions will not be seen, your arguments will not be seen as a devaluation of the non-conceptually conceived child. Yeah.
Yeah. They're all equally valuable.
Yeah.
The point is that the women is subject to discrimination, and so on. Those are my submissions, unless there are any further questions that I can assist for. Oh, excuse me, I didn't check with my junior. I beg your pardon, do excuse me. Mr. Royston is giving me chapter and verse on what's positive, what's affirmative and what's negative.
Would it be better to put that in a note, perhaps?
Certainly,
Yeah.
I will do that.
Yeah.
Maybe we can make that an agreed note.
Or an
Yes,
agreed
there's
note.
not
Just-
anything
we just need a
between us,
position,
just
that's
in
all.
terms of
Yes.
And it's not helpful to talk about the regulations, it's which regulation, 'cause
Of course.
at different times there will be
Yes.
a difference. Their day may be different from something else, I don't know.
Absolutely, yes.
Thank you. Subject to Mr. Royston's now predicted industry on that topic, does he wish to add anything further on your submissions? No, thank you very much. Thank you.
Thank you.
Thank you, yes.
My lords, my lady, can I begin with an apology? My voice is somewhat lower than usual. If it becomes difficult to hear me, please wave and I'll dig a lozenge out of my bag.
There's a lot of it about at the moment, I'm afraid, Miss Ward. Sorry for your suffering.
So, I hopefully won't have to detain either you or strain my voice for too long. I have three areas on which I'm intending to address the court, subject, of course, to anything else on which I can assist. Those areas are, firstly, the proper approach for this court in the light of the Supreme Court decision in Schvidler. Secondly, the proper approach in this case, whether it's this court doing it itself or reviewing the approach of the judge below, to the margin of appreciation, given in particular the nature of the issue with which we're concerned. And that will really encompass my submissions on my learned friends grounds 2 and 3, because the way in which ground 3 arose was actually, I think it came from my response to a question from the judge about where does this idea that women will care for their own children come from, and is that a part of the legal system in general. So I think all of that, grounds 2 and 3, goes to margin in one way or another, and then I will address the submissions that are made in relation to justification. So starting, and I hope I can finish this topic before the short adjournment, with Schvidler, I have to say something about it, although in common with my learned friend, of course what I ultimately say is it won't make a difference in this case, because in my case is the judge got it right, and for the reasons that she gave. We've dealt with it in our skeleton argument, paragraphs 25 to 26, and I know that the court has been taken to Schvidler already, but if I turn up firstly those two paragraphs of our skeleton argument, we do say that the Secretary of State's primary position is that this is a case in which a review approach is appropriate rather than a full rehearing. And it may be that those paragraphs become somewhat more intelligible when I've shown you the parts of Schvidler that I want to show you just very briefly. Schvidler's tab 17 of the authorities bundle. And my learned friend took you to quite a lot of it. Can I ask you to start at paragraph 148 on page 412? Of course, what Lord Sales and Lady Rose have done running up to this point is to identify the two broad approaches, and there's nothing between us on what they are and the different strands of case law that get us there, and the Supreme Court's ultimate synthesis of those in the judgment in Schvidler. Paragraph 148, they say that the need for an appellate court to provide guidance or to determine matters of social importance according to its own exercise of judgment, so that's the rehearing approach, varies with the circumstances of the case and with the state of law at the time the issue of proportionality arises. So it's not it's not a one-size-fits-all, but it is a fact-sensitive assessment based on the circumstances of the particular case. Then, turning ahead to paragraph 157 on page 415, said there that the fact that a case may involve a matter of general legal principle or a challenge to the application of a legal rule or general policy which covers many cases, is that this may be a powerful reason for the court to adopt an approach requiring its own assessment of proportionality. But that will not necessarily be appropriate in all such cases. So the fact that this is secondary legislation of general application doesn't of itself mean that the rehearing approach is appropriate. And as it said at paragraph 158, we say is relevant to circumstances of this case. A previous appellate decision may already have provided relevant guidance about the proportionality of the general rule or policy. And we do say it is significant. I don't say that's a direct analogy here because I absolutely accept that the detailed design of the exceptions was not before the court in SC.
No, because they were looking at the two-child policy.
Yes.
Now we're looking at the variations on that for non-consensually conceived children.
But what they have done is to review the lawfulness of the aims pursued here, and also to identify the the sorts of issues with which we're concerned.
Isn't that just to say that it'll make our job a bit easier rather than that we don't have to do the job at all?
Well, you have to do the job of dealing with the appeal. So no one's suggesting you don't have a job to do here. The question is what approach you take.
Yes, but what I'm saying is that at the moment it looks like a general policy. It looks like it's pretty important to a vulnerable group. There's nothing that deals with it directly. There are some things that might help us when we come to it, but it does look, at first blush, as if this is the sort of thing that Lord Sayers and Lady Rose had in mind.
Well, I'm going to come on to the sorts of things that Lord Sayers and Lady Rose had in mind. I just wanted to say, to make that point, that the bigger picture has already been the subject of detailed consideration. The aims relied upon, which are actually the same aims, have been considered in some detail. And the issue that's dealt with at the bottom of that page 415, in the same paragraph, about institutional competence, has in particular been the subject of consideration. And I will obviously come on to what I say about SC and the no process of legal reasoning point. But I do say that that provides relevant guidance, and therefore that paragraph, those considerations, that is a relevant consideration. Of course, what Lord Sayers and Lady Rose actually said in paragraph 160 is that there is a spectrum with a paradigm at each end. Paradigm rehearing case is something like SC. Challenge to new primary legislation, as they say there, first consideration at appellate level of a new legislative regime of general application, especially one with considerable significance for society, and that's contrasted with the paradigm at the opposite end, a one-off decision of a judge or an official which depends entirely on the application of well-established law, etc. And what I say is, this isn't either, so it's not either paradigm. We are somewhere in the middle. We are secondary legislation.
Probably nearer the first than the last, isn't it? Because it's maybe secondary legislation, but it's going to have wider application. It's not determined by the facts of the individual cases, although they provide exemplars. Why isn't it the type of case that falls closer to the top end than the bottom?
Well, I think the only further submission I want to make on this topic is, as the court goes on to say in the following paragraph, the starting point is review. So it's not, as I think when any friend put it, that review will sometimes be appropriate. Review is the starting point. So if this court is going to conduct its own analysis on the rehearing basis, it has to identify the reasons why it's going to do that. And then paragraph 163, which I think actually identifies really what both of us are going to be asking you to do.
Well, looking at 162, the factors that leap out, the adoption of a more intensive role, so it makes its own assessment, will depend on a number of factors. The main factors, well, 2 leaps out to the nature of the measure in question, since the constitutional responsibility of the senior court is likely to be engaged in a more acute way in relation to challenges to primary or secondary legislation. And then little 6, the high importance for society of the issue to be resolved. Well, this is discrimination against women. Indeed, one might say discrimination against a particularly vulnerable group of women. And isn't society quite concerned about that?
Yes.
So you
I
accept
don't
it?
shy away,
Yeah,
from the proposition that there are factors in this case that tend towards the rehearing.
Yeah.
But the question which this court will have to grapple with is whether they get it over
enough.
that line. And the Secretary of State's primary position, set out in paragraphs 25 to 26 of the skeleton, is that, as I've said, the Supreme Court's judgment in SC forms the backdrop. This is a detail rather than a general rule that affects all benefit claimants. It's not going to be applicable across a wider range of cases. It's limited to the specific exception that's made for a specific group of people. It's a fairly technical element of secondary legislation, and there aren't any divergent strands of authority to be resolved. So we say all of that has to be taken into account. The other point, final point on this, which will take us to the short adjournment, I think, is that you'll see at paragraph 163.
You say we should hedge our bets.
I say the Supreme Court has told you to hedge your bets.
And you know, that might be why permission was granted. You never know. Goodness knows. But I mean, it's quite hard even to decide whether to grant permission on this, because you don't know when you read the papers what you're supposed to be doing. Anyway. My Lords, my Lady, it is a particular feature in this case that the 2 alleged errors in the judge's reasoning actually go to this question of margin and the nature of decision to be taken. So if the judge was right on those, it's actually vanishingly unlikely you disagree with her decision. The arguments on justification, which obviously I'm going to come on to, depend on it being appropriate for any court to resolve what I say is fundamentally an issue to which there isn't a legal answer. And if you're not with me on that, judge probably got it wrong in approach, you're going to be remaking the decision anyway. That's obviously getting ahead to my submissions on the other issue. But what I do say is this isn't a case in which either of us say that the approach you adopt is likely to materially influence the outcome. So that's all I want to say about Schridler. And
perhaps after, it would be most convenient to address you on the two other issues after the short adjournment.
Right, thank you very much indeed. And actually, curiously, that clock I think is 5 minutes slow. So
Yes,
we
so I was looking at the clock on my laptop.
Yes,
so
as
I am
indeed
right.
am I. It is 1 o'clock. But we will start at 5 to 2 by that
By the
clock.
clock.
2 o'clock
2
by
o'clock
everyone
by
else.
everyone else.
Thank you very much.
All right, able.
You're fine.